Good afternoon, everyone. Welcome to today's iteration of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano, and I'm an employment lawyer with Samfiru, Tumarkin, LLP. I work at our Toronto office. As always, if you have any questions, feel free to ask them right away, whether on Facebook, LinkedIn, Twitter, X, YouTube. I'll do my best to answer them live. You can also go to our website at employmentlawyer.ca, email us at help@employmentlawyer.ca, or call us at 1-855-821-5900. I've got a couple of topics I'd like to talk about before we get into everything today, answering your questions. The first of which, because today is March 1st, is talking about the leap day. So over the past couple of weeks, the weeks leading up to February 29th, we were asked on a number of occasions, a lot of our lawyers, whether or not employees get extra pay during a leap year because there's one extra day, and in this year it fell on a Thursday, yesterday, February 29th. The short answer to that question is no. On a leap day, employees don't get extra pay. There's already variability in the amount of working days in every year. So there's 52 weeks in a year and 7 days in a week. 52 times 7 is 364. So there's already that one extra day per year where there's variability on how much work could be. That extra day might be a Saturday, but that extra day might also be a Tuesday, Wednesday, Friday. So because of that, with that understanding, there isn't an extra day's pay that employees are entitled to during a leap year. Also, in most employment contracts, employees are paid on an annual basis or per annum. So you make X amount of dollars per year. And because a year isn't defined in any legislation as being 365 days, because the leap year has 366, it's still just one full year. So the employees aren't entitled to any additional pay. The exception being, of course, is employees who earn wages on an hourly basis. So if you're an hourly employee and because of a leap year, you have to work an extra day during the year, then you may see an increase in your wages. The second topic I'd like to discuss before we get into your questions today is another round of layoffs in the tech industry. So EA, so Electronic Arts, recently announced that they're cutting about 5% of their jobs, 5% of their employees in the latest round of layoffs. This is another announcement in a large line of layoffs, terminations that we've seen across the tech industry. Previously, they announced they were cutting off EA announced they were cutting off 6% of their staff. Sony said they were cutting 900 jobs and closing one of their game studios, and Microsoft eliminated 1,900 jobs. Now, we don't know where those jobs are going to be. They may be from some of their American employees, Canadian employees, or even employees overseas. But one of the important things to remember is when you are laid off, even if it's because of big corporate restructuring, as an employee, you're still entitled to severance. Doesn't matter that the company is going through financial difficulties. It doesn't matter that you might have been working in a department that was losing money. The company is laying you off without cause, which is what happens in these restructuring cases. You're still entitled to a full severance package. Now, what is a full severance package? Depends on the circumstances of your employment. Our courts look at a number of factors in order to try to ascertain how much severance someone might be entitled to. The biggest ones are length of service. So how long were you with the company? Your age. So are you younger and maybe you have an easier time finding new work, or are you later in your career and it's difficult to find a new job when you're 60 and 70 years old? And then lastly, the availability of similar work, right? Is this a industry where there are a ton of jobs and a ton available for you to pick from? Or is this an industry where it is extremely niche and difficult to find positions? So weighing those factors, a court can award a severance package worth as much as 24 or 26 months. So if you're let go, and even if you let go, and even if you think that first offer is fair and you think, it's pretty good, still reach out to us, give us a call, or go to our website, employmentlawyer.ca, and schedule a time to speak with one of our lawyers or paralegals. They'll be able to take a look at everything and really give you a good idea on how much you're entitled to and how the company's first offer in this layoff fits within that. Jumping into your questions now, there's a question from Honey on YouTube. I work in a commercial food production facility as a supervisor. I've historically worked Monday to Friday with the occasional need for some weekend or evening work. A new CEO has started and said that if I want to guarantee a weekend off, I have to use vacation days. Is this legal? So, honey, the question is this legal is obviously is a little bit ambiguous. What I think you're getting at, though, is are they allowed to do this? Is a new CEO allowed to come in and say, you worked weekends before, or you never worked weekends before, and you are now? The short answer is no, honey. When an employer makes a substantial change to the terms of your employment, the employee has a right to treat that as a constructive dismissal. Now, what is a constructive dismissal? It's when, like I said, an employer makes a substantial change to the terms of your employment, and you as the employee have the right to either accept them, right? So say, all right, I'll start working weekends and using my vacation days if I want weekends off, or resigning and claiming constructive dismissal. Now, what these cases always boil down to are, is this unilateral change substantial? In your case, going from a regular Monday to Friday shift, of course, some occasional shift coverage on a night or a weekend, going from that to regular weekends, that's probably a substantial change. It would, of course, depend on your industry and would depend on the individual factors of your employment. But generally speaking, them forcing you to now work weekends, them changing you from a day employee to a night employee is a substantial change to your employment, and you are therefore allowed to treat that as a constructive dismissal. Before resigning, before taking any action, give us a call and speak to one of our lawyers. But what's very important is that you don't accept the change, right? There's no bright line rule that says, within X number of days, within 1 week, 2 weeks, 1 month, an employee has to reject this change. But there is, a time frame where if you start doing that, doing as a CEO is directing, you may be deemed to have accepted it. So what's important now, honey, is that you reach out to one of us as quickly as you can, speak with one of our lawyers so we can talk about your file and whether or not you can claim a constructive dismissal. And if you can, how much severance you'd be entitled to. I'm not sure if I mentioned this, but just in case I didn't, when you are constructively dismissed, the court treats it as a without cause termination, right? So our courts would look at your case and say, was Honey constructively dismissed? Yes or no? If yes, how much severance is she entitled to? And that severance would be the same as if you were terminated without cause. So again, could be as much as 24 to 26 months, depending on how long you've been with that company and the availability of similar work. Val on Facebook asks, my employer is restructuring due to business decline and my position has been eliminated. I was offered a new position. It's similar to what I was doing before. If I reject the offer, is that considered a resignation or can I file for constructive dismissal? So Val, it depends on what that new job is. It depends on what the circumstances of that employment are. If your job is being eliminated, but you've been offered one that is similar in all ways, so similar rate of pay, doesn't necessarily need to be the same. If you're making maybe $1,000 or $2,000 less, that's still considered similar, but similar rate of pay, similar hours, similar work location, then you don't have to accept the job. But if you choose not to, then you would likely not be entitled to any severance or Now, again, it depends on the case, right? It depends on what the job is. If you're going from a desk job, a lawyer as an example, where I'm sitting down for 8 hours a day, and then the job I'm being moved to would be a manual labor job, well, that's a substantial change. So it really depends, Val, on what the change is and what the implications of that change are. So again, as with any constructive dismissal case, it's always best to speak with a lawyer so you can know exactly what you're entitled to and whether or not you have to take that job or whether you can claim constructive dismissal and seek a severance package. Rudy on YouTube asks, I work part-time for a company. The minimum for this is supposed to be 18 hours. If I'm getting less than that, is that illegal? So again, the illegal question, I think, is that allowed? It depends, Rudy. If they say in their contract the minimum is 18 hours, but they have throughout your tenure been giving you less than that, well then it's likely that is you've accepted that change, and that's what I mentioned a little bit earlier. When a change is made to the terms of your contract and you do nothing and you just continue working, the courts say you've accepted it. So Rudy, in your case, if you've been working at this company, the contract, always said 18 hours, but for the past 2 years, you've been working 14 hours a week, then there's likely nothing you can do at that point. However, if you have routinely for a prolonged period of time worked 14 hours or worked 18 or more hours a week, and then only recently they started reducing your hours, reduced your hours to 16, 15, 14, then it is possible that that's a constructive dismissal. It's possible that that's a constructive dismissal. So I think the question for you, Rudy, is that new? Is that reduction in hours new? Or is that something that's been going on for a while? If it's something that's been going on for a while, then I don't think you would really have a case. But if it's something new and it's resulted in a substantial change to your rate of pay, then it is likely you've likely been constructively dismissed and you should reach out to us. S from YouTube asks, if I was making LOA and travel, will that be included in my severance? Does a person get a rate based off your hourly wage? So I'm not sure what you mean by LOA. I'm assuming travel, you mean reimbursement of travel expenses. So in a severance package, you're entitled to your entire remuneration package throughout the severance period, right? So if a judge awards you a 24-month severance period, you're entitled to your full 24 months of pay. So that includes base pay, that includes a benefits continuation, and then it can include other things as well. What the bar or courts say is, what position would you have been in if you continued working for the company, right? So if instead of terminating you, they had said, we're going to let you go in 2 years, consider this a working notice period, how much money would you have earned? So something like travel expenses, reimbursement of travel expenses, that's likely not something you would receive in a severance package because you've been let go. You're not incurring those travel expenses any longer, and you are instead just not working. So no, you wouldn't get that. But if it was a allowance because you work in a big you live in an expensive metropolitan area, as you responded, said living out allowance. So if you're getting an allowance because you are living in a city that is more expensive and they're paying you an additional sum compared to the other employees, then yes, that is likely something you would continue to receive. Really, it becomes a fact-specific, case-by-case analysis on would you have received that if you continued working for them, or would you have received them if you continued working for them? Reimbursement of expenses generally aren't those things. So if you get paid back for mileage, or if they reimburse you for flights that you take on behalf of the company, because you're not accruing that mileage, that expense, you don't really get that in a severance package. Trevor T on YouTube asks, I was let go right before taking medical leave. My boss was aware of ongoing health problems. Is there any way to prove this was discriminatory? So Trevor, there is a way to prove it. It is generally difficult to prove. Discrimination unless there's some sort of smoking gun. It's difficult, right? Most employers, not all, but most employers are smart enough not to put that kind of thing in writing. With that being said, if there's a close enough temporal nexus, there is grounds for a judge to still award damages even without a smoking gun, right? So it depends on what how you notified your boss and whether he was involved, and then it also depends on what precipitated the layoff, right? The rule is with any kind of discrimination, if even 1% of the reason you were let go was because of a protected ground, then it's discrimination and you can pursue additional damages. What are the protected grounds? There's a number of them. They're outlined in the Ontario Human Rights Code for provincially regulated employees and in the Canadian Human Rights Act for federally regulated employees. But in general, they are disability, so any type of injury or medical problem, gender identity, gender expression, sexual identity, age, race, religion. There's a number of them. and employers are prevented from discriminating against you on that. So Trevor, in your case, if your boss said, hey, we've got to lay a bunch of people off, Trevor's about to go off anyway, so let's terminate his employment, then that's discrimination. Absolutely. Now, if you had told your boss, I'm going to go on a layoff, and they already had plans to cut a whole department that you just happened to be in, then that's not discrimination. So, well, it's not easy to prove. It's not easy to prove, it can be proved. And when we are able to prove it, we're able to get additional damages for our clients. So Trevor, I think in a case like yours, again, important you reach out and speak to one of our lawyers so they can help walk you through exactly what you'd be entitled to. S on YouTube has us a follow-up question. How long does a case generally take after paying the input fee? So as it depends. Our cases resolve in anywhere from as little as 1 to 2 months to as many as 1 to 2 years. It really depends on the case, and it depends on the willingness of the employer to settle. Unfortunately, our court system is incredibly slow right now. Doesn't matter how hard we work, it still takes 2 to 3 years to get in front of a judge and get an ultimate decision. And because of that, and that's well known, right? Lawyers know that. It's not something that's unique knowledge to me or unique knowledge to our firm. Every employment lawyer and every litigator in the province knows how backlogged our courts are. Now, a lot of reasons for it. There was already a backlog, and then COVID hit, and there's a number of judicial vacancies that haven't been filled for years, which has led to this backlog. So sometimes companies decide to play it slow, just say we'll pay when we have to, but not before. And in that case, we do have to go all the way to court. That said, the vast majority of our cases will settle within 6 to 8 months. But we can't ever guarantee how long one specific case will take. It really depends on the facts, how complicated your matter is, and then it also depends on the willingness of the employer to settle. So as always with an answer from a lawyer, as it depends. Sydney on Facebook asks, my employer was quite happy to have all employees work from home during the pandemic as this arrangement suited their needs. Now non-union employees are allowed to work from home on Wednesdays and Fridays, but union employees are not allowed. The company claims to be a fair company, but this doesn't seem fair at all. The union advised they tried to negotiate this in our new contract, but failed as the company just would not discuss it at all. Is there anything we can do? So Sydney, unionized employees fall within a different area of law. So employment law is the area of law for non-unionized employees, and labor law is the area of law for unionized employees. I practice employment law and not labor law, but generally speaking, you have to speak to your union rep. When you're a part of a union, there's a lot of give and take with respect to your rights. And one of them is that you generally are unable to pursue your own remedies through the courts, and you instead have to go through your union. So that's, Sydney, unfortunately, that's a question for your union. That's a question for your union. Whether or not you're a member of a union is not considered a protected ground of discrimination under the Human Rights Code. So it's likely something that does need to be negotiated through them. Lisa on YouTube asks, I'm a sales director for a local transportation company. For this year, the company is implementing a number of new cost-cutting measures across the board. For management, our bonuses are being reduced from 30% to 10% of our salaries. Am I obliged to accept this? So Lisa, again, it depends. How much is that 20% of your base salary worth? Obviously, it's huge. 20% bonus, 30% versus 10% bonus is quite large. But in terms of real dollars, how much is that worth? Going back to the constructive dismissal topic I spoke about earlier, whether or not such a big change is enough to establish a constructive dismissal depends on whether or not it is substantial, right? So if that 20% change, would result in a reduction of $20,000 to someone who makes $300,000 a year, it's probably not big enough. But if it's would result in an overall 15% decrease in your rate of pay, then it might be. The other question is also, were you getting paid out 30% every year? Right? I understand generally in contracts, the percent listed in the contract is the maximum. right? You can receive a bonus of up to 30% of your base pay. Is that a percentage that was paid out on a regular basis? Did you always get 30%? Or was it more of a case where that was the maximum and you always got 15%, right? So if you made $100,000 a year base, and the bonus could have been worth as much as $30,000 and you only got 15. And now going forward, you'll continue to make $100,000, but they will pay out the full 10%. Well, then the difference is only $5,000, and that's probably not substantial enough. So so the answer is maybe. You maybe have to accept it, or you may be able to reject it, resign, and claim constructive dismissal. Again, if you reach out to one of our lawyers, they'll be able to review your whole situation, review your employment contract, really understand what that change means in terms of your employment contract, and advise on whether or not you're able to claim a constructive dismissal and pursue a severance package. Anna on YouTube asks, can an employer ask for other duties that are not assigned for the job position? So, and it depends. Generally, if the duties are similar to the ones you already occupy, then yes, right? So if you are a data entry clerk and you've been inputting the same data into one system forever, and now because of changing business needs, they also want you to enter data into another program. Yes, they're allowed to do that. The employers are allowed to make small changes to your position throughout your employment, provided they aren't, complete changes in the nature of the job, right? So if you were an office employer an office employee, if you're a dispatcher at a trucking company, as an example, right? And then after a few years, they said, okay, Anna, we want you to go be a truck driver. Well, that's a substantial change, right? That completely changes the nature of your job. You're going from a desk job to an out-of-office job. And even if the rate of pay is staying the same, it's still a big enough change. It's still a big change. So yes, they can ask you to do things that weren't previously part of the job description. Of course, recognize that businesses and the marketplace in general evolves, and there's a need for that. But it depends on what that new thing is. Again, if you are an office employee and now all of a sudden they're expecting you to be a janitor, huge difference than if you are going from an accounts payable clerk to an accounts receivable clerk. So it depends on how big that change is and how outside of your job description those new tasks really are. Georgina on YouTube asks, my employment agreement states my workplace is my home. The company says return to office for work policy trumps employment agreement. Employment agreement does not state anything of this sort. So, Georgina, if you were hired during the pandemic, which it kind of sounds like you were, and it says that your workplace is your home, then that's your workplace. And then requiring you to return into the office is a substantial change to the terms of your employment. You do not have to accept it. You do not have to go back into the office. And instead, you can resign and claim constructive dismissal. There's nothing we can do to force them to allow you to continue working from home and continue, receiving your paycheck. But if they are now making that substantial change, being working from home versus working in office, you do have the ability to pursue a constructive dismissal claim and a severance package. One of our lawyers will be able to help you out with that. Just go to our website at employmentlawyer.ca and you'll be able to get in touch with one of us. Says, how much does a lawyer generally take off? The top of a potential awarded severance. Again, as it depends on your case, depends on how much it's worth. You can either be engaged on an hourly container or a contingency retainer. Both have their pros and cons. Without knowing the specifics of your case, I don't know how much the legal fees would be. And also asked, so it's not really worth going after severance if you worked only around 6 months for a company. The time and cost would outweigh the benefit. Probably. Again, it depends. There are many cases where very short-term employees, 6-month employees, have received 6-7 month severance awards. Our courts have said that short service shouldn't have an unduly heavy weight on the severance award. It really depends. And of course, how much money you make. 6-7 months pay can be a ton of money for some and less money for others. So, it sounds like the case with all my answers to you today, how much you'd be entitled to, whether or not it makes sense to pursue it, how much the legal fees would be, all depend on the specifics of your case that I won't really be able to get into in this forum. But if you've reached out to one of us, whether through email at help@employmentlawyer.ca or called us at 1-855-821-5900, one of our lawyers will be able to help you out. Al-Karim on YouTube asks, after I got fired for cause, working for 23 years, and I'm 57, they offered me $8,000. I didn't sign. They said, get out of the office, don't come back, and they don't want to hear from my side. They left. How much severance am I entitled to and punitive damage? So again, it depends. There's a lot of things more than just your age and length of service that we have to consider. Availability of similar work, whether or not you were management, or other things to consider. But for a 23-year employee, 57 years old, it could be as many as 24 months severance is what the judge may award you. Whether or not you'd be entitled to additional damages, whether it be punitive, general, moral, bad faith damages, again, depends on the facts. I don't think that one termination meeting in and of itself is enough. However, if there's more there, you may be entitled to it. Also, they're firing you for cause. What happened, right? What really happened? What are they trying to rely on to establish just cause? If it is, is it actually cause, or is it a situation which we often see where employers will say, we had just cause to let someone go when they really don't. So again, reach out to us. One of our lawyers will be able to take a look at your case and really give you a good idea. Just cause in Ontario has been called the capital punishment of employment law. That inflammatory language isn't a mistake. Just like capital punishment in criminal law is the most extreme conduct reserved for only the most egregious crimes. Termination for just cause is the same. So again, reach out to us, employmentlawyer.ca. One of us will be able to help you out. Samir on YouTube asks, I run a small business and I've decided we have to let an employee go. He's a good worker, but causes too many issues with other employers. He's only been with us for 2 years as part of our sales team. How much severance should we offer him? So Samir, again, it depends. How much does he make? What's the business like? What's the sales role like? Especially with businesses, do you have an employment contract? Is he not on a contract? There's a lot of things that need to be considered when you're letting someone go. Not just, like I say, how long he's been there. So Samir, especially, I encourage you to reach out to us, employmentlawyer.ca, and one of our lawyers may be able to help you out with your case. While our bread and butter is employees, we do help out employers as well. So definitely reach out to us, and one of us will be able to help you out. So for my last question for today, Carol on Facebook asks, is your employer obligated to fulfill bonus promises? So Carol, it depends on where that bonus promise came from, and what do you mean by fulfill, right? So if you have an entitlement to a bonus in your contract, and that's the promise you're referring to, then it depends on what it says. If that bonus is based on company performance and the company hasn't met the performance targets, then they don't have to do it. If the company says it's based on personal performance and you maybe didn't hit your targets, then no, they don't. But if it's more of an objective thing, right, and you've met those targets, you've met those goals, then yes, they do have to pay out your bonus. It really depends on what the bonus is for, whether it's discretionary or automatic, and again, how much is it worth with respect to your to your base salary. Not that they don't have to pay it out if it's an objective bonus you're entitled to, but if the company refuses to, and your bonus makes up a very substantial part of your employment package, then you may be able to pursue a constructive dismissal if they decide not to pay it out. So again, Carol, it depends. It really depends. So you may want to reach out to us if the company refuses to pay it. But if that promise is just, somebody, your manager saying, oh, we hope to pay bonuses of around 4% this year, and then they never paid them, it may be difficult to have that enforced. So thank you all for joining us today. Again, my name is Teilen Celentano. I'm an employment lawyer with Samfiru, Tumarkin LLP. And this has been today's live employment law Q&A. Our next one is on Monday, March 4th, 1:30 p.m. Mountain Time with my colleague, Luke Serta. Thanks and have a great weekend.